Opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. I'm Stuart Address for Ask a Lawyer on June 11th, 2021. I am back from a 2-week absence. So Greg, let me ask you a question. What would you call it if I told you that somebody sat in a chair for an hour and a half and stared at a sleeping woman?
That happens every day in Congress.
But if it happened in a local house.
Oh, gee, that sounds like a thrilling afternoon.
Okay. You're not playing well. I thought you'd say it was creepy. It was, concerning at the least. Well, I woke up one day last week, which is why I missed last week's show, and I got myself to a chair, and I found I couldn't move a muscle. I couldn't move a millimeter. I had back spasms everywhere, shooting from every angle. And so I ended up sitting in a hardback chair at night. My fiance was still sleeping, and I stared at her for about an hour and a half. Didn't want to wake her up, didn't want to move because I didn't want to be screaming. And so I just sat still until she woke up, and we managed to get me over to the phone where I immediately called my doctor. Anyway, I am back after 2 weeks, and she no longer has to worry about me sitting there staring at her. I'm told on Facebook the sound is choppy. Greg has already told me about that. We'll be getting some new equipment, and hopefully we'll make it easier for everybody. So when I was last live with you, we were continuing a discussion about severance agreements and non-competes and things like that that are often included. But before I try to go back to that topic, there's all sorts of information to discuss. I want to say that Ask a Lawyer is not just a radio show. It's reality. The earlier you ask a lawyer, the better. If you wait too long, the strength of your case may weaken, or it may disappear entirely. Indeed, you wait too long, and the statute of limitations might even expire. Now, this week, I got a telephone call from a lovely, sweet woman who had worked in her job for over 20 years and had been transferred to a different location where there were a lot of younger people, and they were giving her a horribly hard time. They were making fun of her age. They were passing around sexually explicit pictures. They were doing all sorts of things. And she did the right thing in complaining to Human Resources. And nothing improved. In fact, it got worse for her. And she was getting stressed and going home upset. And finally, she decided to give her 2 weeks' notice. Now, a month later, after she's lost her health insurance, she's called me to ask a lawyer. Now, there's a real problem here. And I told her this. If she had called me before she resigned, I could almost certainly have helped her. I would, in fact, have done what I've done for some other clients. I would have drafted a complaint email for her to send herself, but written my way, that would have made sure that if we ever had to use it in court, Human Resources could not say they did not have notice, and that they did not have notice that she was now being retaliated against after having initially complained. And then, if she really needed to leave, I would have drafted her resignation as a constructive discharge, that she left because nobody responded to her cries for help initially, or when she complained about the retaliation she was receiving. And therefore, this should not be viewed legally as a resignation. It should be viewed as a constructive discharge. Now, forget about the fact that that would entitle her to unemployment. Really, it helps build the basis for the demand letter that I would send the employer and for the eventual lawsuit that might have to be filed.
Isn't constructive departure the same as firing?
Well, it is. It's like they didn't fire you. It's considered a termination constructively because of what they have done or not done. That's why we call it constructive discharge. And so I had to ask her some very hard questions about, why didn't you call me or somebody else sooner? Why did you resign a job that you'd been in over 20 years before at least calling a lawyer? And there were a number of responses, none of which really were legally sufficient, understandable in the human day-to-day context of life, but not legally acceptable. And I asked her, did she have any emails or text messages of her complaints to Human Resources initially, or of complaining to them after things got worse and she felt she was being retaliated against? And her assignment now over the weekend is to try to find the best of whatever she has and send it to me, because I told her the fact that she resigned creates horrible complications. But if I see some really strong language of her complaining, then I might be able to work a way around it. Not optimum, maybe not even a case I would take to court, but at least one that I might do a demand letter for and see if we can negotiate a severance agreement.
Okay, I got a case for you out of the news.
Okay.
Houston Methodist Hospital, 180 nurses refusing to take a vaccine. And Houston Medical Center is talking about letting them go.
I had this question posed to me just the other day. I actually think the employer is correct, and I'm an employee's attorney.
Wow.
The vaccine issue is a very sensitive, politically charged issue, unfortunately. And in terms of employee law, it seems to me, remember we talked many times when this pandemic first began. We had some shows where we discussed, if you felt you were being forced to go to work and you were afraid of catching COVID, did you have any recourse? And we talked about how OSHA requires employers to ensure that you are not risking death or serious bodily injury coming to work, but that you can't sue under OSHA. You could sue under other statutes like Title VII of the Civil Rights Act. You might be able to sue under the Americans with Disabilities Act. We talked about this, and here it is in action. And this has been happening. There are several cases which have already been filed. Can my employer make me take the vaccine? I honestly believe the answer is yes. And to be consistent with what I said earlier in the pandemic about employees being entitled to protection if they were afraid to go to work, now we have a vaccine, and the question is, if my employer doesn't require the vaccine and I catch the coronavirus, may my employer be liable? He has a duty to ensure that my workplace does not present an unreasonable risk of death or serious bodily injury. So in that context, if the employer chooses to require its employees to be vaccinated, that would seem to be consistent with the obligation under OSHA. Reverse, if the employer doesn't require that and an employee contracts coronavirus, might that employee then have a claim against the employer now that there is a vaccine? So here you have, unlike some people, Republican clips I've been seeing, Democrats do it too, where they said one thing 2 years ago and now they say the exact other. In the beginning of the pandemic, as an employee attorney, I was absolutely on the employee side. You're concerned about going to work because of getting this. I think you have a right under the disability laws, given how disability is defined under the statute, to work remotely or to have a leave of absence. There have been cases filed because of employers forcing you to come to work. Now, if I'm going to be consistent, I have to take the employer's side. And I have to say, now that there's a vaccination available, and the employer has that obligation of ensuring the safe workplace, I think you have to say to the employer, yes, you can require your employees to be vaccinated.
Yeah, CNBC last night had a secondary story to that. One was, it's a smaller hospital, but they had 8 nurses. And what management did is turn around and tell the 8 nurses that they could go to the back office and off the front lines and become coders in the office. Of course, their salaries would not stay the same,
Right.
but they offered that alternative to them, which I guess the nurses turned down.
And I think that's a reasonable offer as well. If the employer is going to say, you must be vaccinated, and you don't want to be, and the employer says, well, I'm not going to let you work in the area where you might cause somebody else to contract it, but I'll give you another position, whether remotely or in a back office, what have you, but it's not the same position, and it's at a lesser pay. I think that's a reasonable effort to accommodate the employee's desire not to be vaccinated. So, these are not only touchy subjects, but they're also practical subjects. And you got to look at the interests and the needs of both the employee and the employer. And these are lawsuits that are pending in several states around the country already. And I'm sure before the pandemic is over, we'll have some guidance, but hopefully the pandemic will be over before the matter is settled and we won't have to deal with the issue. Interestingly, there are lots of, sports stadiums and arenas are permitting unvaccinated people in, but they are putting them into separate sections from those who are vaccinated. Those who are vaccinated get access to better seats. I think that's perfectly defensible. Now, it's not in the employment context, but it makes sense to me. And sometimes what makes sense is what is going to turn out to be legal. And very often, what makes sense will turn out not to be lawful. And, I find that unfortunately all too often over 35 years. It makes too much sense and it's not the law.
Of course, we all know college athletes are not paid, at least now. What about colleges that demand that their athletes are vaccinated before they come back to school?
Well, now if we're asking the question about college athletes and the requirement that they be vaccinated before they come back to school, we take it out of the employment context. So I don't think OSHA has any application. The Americans with Disabilities Act doesn't apply. None of these employment laws that I deal with are applicable. And I honestly don't know whether a college can require an athlete or a student to be vaccinated in the interests of health for the overall student body. To me, that makes sense. But again, I don't know whether I have not looked at that, whether that would be something that could be required.
That's going to be a whole interesting dilemma as we start school.
It may be. You may find that some schools decide this dorm is a vaccinated dorm, this is an unvaccinated dorm.
There you go.
To try to deal with those issues. This part of the cafeteria is a vaccinated part. This is the unvaccinated part. Schools may struggle to do what they can to try to accommodate those who are vaccinated and those who are unvaccinated. It is not an easy question, and I think there will be struggles, and I think there will be lawsuits. There are always lawsuits, otherwise lawyers wouldn't exist. And just as with everything, as with what we were just discussing, I would say, if you're going to question these issues, then ask a lawyer earlier rather than later. Because the earlier you do it, the more likely, if certain things are necessary as prerequisites, a lawyer can be available to guide you through so that you don't step on minefields by accident. So, where does that leave us? First of all, Cliff said this was a tag team. I want to tell everybody, it's not a tag team between Greg and I. The tag team is between me and my clients, where we assist each other, or me and you, where you ask some questions. Give us a call at 340-1590. Let's talk about questions you may have, issues you may find of interest or may apply to you or a friend. You can always call and ask for a friend. I'm certainly ready to move along with severance agreement issues. I find them fascinating. Maybe you don't. If not, stop me and call and ask me about a neighbor issue. Neighbor's knocking down your fence. Neighbor has a tree that's overlapping into your property and dropping all sorts of leaves and fruit and coconuts. What can you do about it? Neighbor is playing sounds late into the night. I've dealt with so many neighbor conflicts. I wake up and I don't know. I'm suspicious of my neighbor. Not the way it used to be when I grew up, where the neighbors had the keys to our house. Those old people, those good old days,
Get off my lawn.
Get off my lawn. I do remember that one when I would cut through the backyards, but most people didn't mind if I would cut through backyards to get someplace. There were those that get off my lawn. Absolutely.
Are there rules, federal rules, if you will, about severance pay, X amount of weeks per X amount of years or anything?
There are no federal requirements regarding severance pay, regarding amounts of severance pay. That is between the employer and the employee. And that's why so many of these agreements that are being presented to employees, they're not out of the goodness of the employer's heart, most of the time. What they are is an effort to get you to sign a release that there are no claims that you have against the employer, and that you've given up any claims that you might have against the employer. Now, you sign that document and then you ask a lawyer, it's too late. Hear me? It's too late. You signed it. The time to ask a lawyer is when you get that proposed severance agreement. If you think you might have a claim at all, then you've got to call a lawyer.
I got a good one, though. Disney's involved, which is a buddy of mine at ESPN, who never signed a severance agreement, but his agent did. He never saw the agreement.
Well, that's interesting. So the agent is the agent of the principal.
Yes.
And the agent might be acting in the course and scope of his employment, in which case the agent can bind the principal. And therefore, the athlete, let's say, might be compelled to abide by the severance agreement, although he might have a really good lawsuit against his agent.
Oh, now you add a new wrinkle to it. Okay.
Well, yeah, you know, if any, as a lawyer, I'm your agent. There are certain things I can agree to, and there are certain things I can't agree to unless you agree. If I agree to a settlement and the other side reasonably believes that I'm acting on your behalf, you may be bound. And if you're bound to a settlement you never agreed to, you may have a really good malpractice claim against that lawyer. And it applies outside the lawyer context. You know, if you hire an agent for whatever reason, and the agent appears to be acting in the course and scope of his employment, you may be bound. And this could even go as far to, you know, assaults and battery. You might be responsible for your agent doing something that is unlawful, criminal even, to a certain extent. Okay. I'd have to prep the show to go into those details, because I do know I've read the cases, but I don't really have a good handle on remembering them.
That would be wild, though. That would be wild.
You know, it's funny. I'm hearing on Facebook that they're having some audio issues too with me, but that's odd because this is not going through the soundboard. This is just me talking with the iPad going. So I don't know why they're having issues, but I do know why the listeners may be having issues.
Well, Facebook was having major issues earlier this week, so that may be part of the problem.
All right. Well, Facebook, you hear me? If you can hear me, Facebook's been having audio issues all week, so ain't my problem. So, you know, let's look at, for example, I'll often see in a severance agreement, whereas the employee resigned. Well, very often you didn't resign. You were let go. And it's important that the agreement be accurate in characterizing what occurred. So I will substitute employee resigned with employee separated from employment. We don't have to go so far as to say employee was terminated. The employer may not want that. It's okay to just say separated, but I personally don't like resigned if it's not true, because I don't know, it may come back to haunt you somehow later on. I can't consider every possible way it may come back to haunt you. And so the best way to do it is a neutral term, which is separated from employment. When you give a release in a severance agreement, I've seen employee has agreed to a general and complete release and waiver of any and all claims. Well, that's wonderful. You're giving up any and all claims you might have against the employer. Sounds fair. Wait a second. Shouldn't the employer also be giving up any and all claims it may have against you? Do you really want to sign a severance agreement only to have the employer sue you the next day? Might as well wrap it up now. So I will change that to a mutual release and waiver of claims.
Have you ever heard of employers that have done that?
You betcha, you betcha, you betcha. Yes, I've heard of employers who have done that. I have seen those documents, and I'm working with one right now. So it happens, and it happens with a level of frequency. Now, very often you're going to find in a severance agreement all sorts of provisions about confidentiality, confidential information, trade secrets, the secret recipe to Diet Coke. I don't know. There's just a lot of confidentiality provisions. But I often see certain things regularly that I seek to change at least. So, for example, some terms will say, during the term of employee's employment, he or she has had access to, come into possession of, and was exposed to certain confidential or proprietary information. And then you get, what's the restriction on use of the information? Well, some of them say that you have not used it and will not use it. I don't want to have not used it. I don't want dealing with the past, because you may very well have used it. And if you sign this document saying you did it, well, then that may be fraud, and you may be breaching this agreement and entitling the employer to sue you. So I try to change it basically from things like, employer represents that she has not accessed or used any confidential information and has not copied any documents, nor has she removed any such documents. Boy, if you've done any of that stuff, and a lot of employees have, you sign that, I'm concerned. So I would change it to something like, employee agrees that she has not and will not disclose, communicate, or copy. And preferably, I take out the has not and I limit it to the will not. So we avoid you making a statement about past behavior which isn't true. Because you don't want the employer coming back and saying, give me back all the money you gave me, laying in wait, setting a trap. That's one thing we don't want to happen. So another thing we have is remedies for breach of this agreement and enforcement of the agreement. And I have one right now. It's really sneaky. Really sneaky. And it's the first time I've actually seen it. This agreement had a provision that said, as a result, employee recognizes and hereby acknowledges the employer shall be entitled, without the necessity of proof of actual damage or inadequacy of legal remedy, to a temporary or permanent injunction and damages. Wait a second. An injunction is considered an equitable remedy. So I understand the reasonableness of a temporary injunction without any additional proof. Of course, a trial is what's necessary for a permanent injunction. But damages without proof? No, I'm not going to agree to that. So I will often try to change it to, the entitlement is upon fulfilling the requirements of Florida law. I don't have to spell out what you have to prove, because you're probably not going to want all that detail. But I might be able to get you to merely accept that your obligation is whatever Florida law says it is. And that makes it safer, because you're not going to get damages without proof of damages. And we can handle it that way. We also have things like, let's see. That's the damage. Oh, we have, this is an interesting one. And it's not just in severance agreements. It's in any contract, anything. We'll have the employer shall be entitled to reasonable attorney's fees and costs in the event they have to enforce this agreement, whatever the agreement is. Well, first of all, I want it changed to the prevailing party shall be entitled to recover fees and costs, not just the employer. But you want to know something? If some stupid employer or employer's attorney was willing to hang their hat on that and die on that hill, and everything else was agreeable, I would let them have their way, because it would truly be a stupid attorney. Why would I let them have their way that only the employer is entitled to recovery of damages and costs? I mean, attorney's fees and costs? Well, because there's a Florida statute. And the statute says in any contract where only one party is entitled to recover fees and costs, the contract shall be interpreted as to provide for prevailing party. That is Florida law. If you're going to put in an attorney's fees provision into any contract, and I mean the employer, the employee, you make a contract with your mother for a loan, you put in an attorney's fees provision, it's mutual. Whoever wins the case, the loser is going to be paying the attorney's fees and costs in addition to whatever else they are able to recover. And that is an interesting little tidbit about a Florida statute, which I don't think anybody would think exists, but lawyers should know. Because if you do anything that has to do with contracts, that is something a Florida lawyer should know. So, you know, one that doesn't know that and really wants to fight that the agreement only say the employer is entitled, I'll let them get away with that if I get everything else I want. And that's the one thing they don't want to give me. Sure, have it your way, because your way is not going to overrule the statute.
Sign a contract with mom for a loan? A contract with mom? Really?
You'd be surprised. Yes. You know, you say don't lend money to family. It's not a bad idea to have a little promissory note with family, because otherwise, not only don't you get paid back often, not often maybe, but not only sometimes do you not get paid back, but then the family relationship fractures. And this family member gets drawn into the dispute, and that member gets drawn into the dispute. It doesn't have to be a 10-page agreement. It doesn't even need to involve an attorney, actually. I mean, it should, but it doesn't have to. Just put something, you know, loan you $250,000. You'll pay me back starting a year from now. You know, no interest. You know, payment term is 10 years. Anything. So that nobody can get confused, even honestly confused, as to what were the terms. I understand why people might not do it with family, but it really is a smart thing.
Well, I want to find a mom who'll give me $250,000.
Now, another thing you're going to find often in these agreements, and not just severance agreements, but a lot of agreements that resolve relationships. Non-disparagement. It says that you will not do or say anything about the other party that is disparaging. Now, why don't I like that? Because of the word disparaging. Disparaging means anything that is unkind. So you say, you know, I really never liked that guy. That is disparaging. And if you've signed a non-disparagement agreement, you might get sued. Now, isn't it stupid to be sued over saying, I never liked that guy? Yeah, it really is. But if it's a non-disparagement clause, you could be sued. Now, they might not get more than $1 in damages, but you might be tied up in court and have to hire a lawyer. I always try to change that to a non-defamation clause, because defamation is relatively clearly defined in the law. It is much narrower than disparagement. You can say all the nasty things you want. You can give your opinion about anybody. That's First Amendment. But for it to be defamation, we've done some shows on this. In general, it has to be a false statement of fact, not your opinion, a false statement of fact. He stole $20,000 from his employer. All right, you're now accusing somebody of a crime. If that's not true, that's defamation. You're in trouble. But I never really thought he was honest. That's disparaging, but that's not defamation. You've expressed an opinion. Now, we can get all involved in another category of mixed fact and opinion and how to classify that, but that's not the topic of today's show. The reality, though, is I would much rather have a non-defamatory, non-defamation clause. Again, mutual. I always want to try to make this mutual. They're not going to do it to you either. I'm not going to have you agreeing that you're not going to do it to them and then have them badmouth you to some future employer that you're seeking a job from. In fact, in the severance agreement, I'm going to provide for what your former employer is going to say to anybody who calls and inquires about you for a new job. And it might be a requirement that it be something very specific and positive, or it could be as neutral as name, rank, and serial number. Yep, you worked here from these dates, this was your salary, and then I'm not permitted to say more, that's company policy. That way it doesn't look like it's applying just to you. This is why you ask a lawyer. This is why you don't do these things on your own, folks. Sometimes people will call. There's not really a case for me to represent them on. I'll give them a couple pieces of advice like I would if you call us at 340-1590. And they ended up getting some advice and they never had to pay for anything. That's wonderful. You never know what you might get if you ask a lawyer. Now, if I have to go into depth, yeah, I might set up a consultation and charge you a few $100. Your decision whether a few $100 is worth it, depending upon the situation you have. If you're looking at a severance agreement that is giving you 1 month's salary, and you've been there 20 years, and you really think that you're entitled to more, I can't tell you that you are entitled to more, but I can tell you this. If you have some dirt on that employer, something that employer might like to keep confidential, and I'm not talking about blackmail, and I'm not talking about extortion. I'm talking about if you have legal information that would constitute being a whistleblower, you can give up the right to whistleblow in exchange for a reasonable severance package.
Wait a minute. That is blackmail.
No, it's not.
Oh.
You're entitled to be a whistleblower. Matter of fact, I know somebody who knew of a confession in a criminal case, and I didn't get involved in this because it was too close to the line for me, but he didn't want to work for this person anymore because of what was going on. And he basically said, pay me, make me sign a non-disclosure agreement, an NDI. We all learned of that with Mr. Trump. And, unless I'm subpoenaed, I won't say anything. If I'm subpoenaed, I have to tell the truth. So I know that he happened to negotiate something with another attorney who I shall not name. I will give one little tidbit to this interesting story. This person had an attorney initially that he had to give up. And that attorney definitely would have crossed the line and done this in a very impermissible way. How do I know that? Because that attorney got disbarred in New York and California for doing something just like that to a really, really big shoe company. That attorney was Stormy Daniels' attorney, Mr. Avenatti.
That's my buddy.
So, you know, I know I told this person when I heard who he had hired that I really didn't think it was a good idea. And sure enough, he had to give him up once he was arrested in New York. And the other side made a lot of noise about it. You know, I mean, your attorney's been arrested. What kind of credibility do you have?
Yeah, it sort of reflects on you.
Now, you'll sometimes see these things about admissions. There's no admission to liability in a severance agreement, in any settlement agreement. Sometimes it says, here, an example. Employee recognizes and acknowledges that this agreement does not constitute and shall not be construed as an admission of any acts or misconduct by employer. I often try to change that to the parties make no admission. Again, not just the employer. So now let's get into what I think is a really interesting topic. And I don't know, you folks might get bored by it. I hope not. I had a call, and this wasn't in the context of a severance agreement, although I actually had it in my outline for severance agreements. I had a call earlier this week about, can we, me and the other side, choose any state to be the venue where any litigation has to take place? And can we choose any state's law as a choice of law? Can we put in the agreement any litigation will be in the state of Idaho and we'll use Nebraska's law? Now, it was an interesting question because we very often see things like, well, New York law will apply. And we'll see any litigation has to be in California. But that doesn't mean that two parties can just pick any state to litigate in and any state's law to apply. So let's quickly look at what the limitations of your ability to make these choices are.
I've heard of doctor shopping, but never judge shopping.
Yeah, right. It happens all the time. Venue, in order to pick a venue where you are going to sue, that state must have minimum contacts as defined by the Supreme Court with the issue at hand. So if you bought a product from Bill's neighborhood bait shop, downtown Jensen Beach, and you happen to live in New York and we're down here, you know, contracting with Bill's bait shop, you can't say Idaho law applies, or you can't say we're going to try this case in Idaho. Idaho doesn't have sufficient minimum contacts, or the defendant that you want to sue, the bait shop, doesn't have sufficient minimum contacts with Idaho to expect that it will ever have to defend a lawsuit there. So in order to have a venue, a location where the litigation is going to occur, you must have the defendant person being sued must have sufficient minimum contacts with the case at issue to expect it reasonable that they might be sued in that jurisdiction.
So say you had a summer home in Idaho and you're that New York person.
Well, that's the plaintiff, not the defendant. The defendant is the bait shop over in Jensen Beach.
Yeah, okay, gotcha.
And does the bait shop have any reasonable expectation that it's going to be sued in Idaho? Now, if there's this lovely stream in Idaho and the bait shop happens to have another bait shop in Idaho, you might have sufficient minimum contacts. But you can't just go somewhere because you think it'll be fun to litigate in Las Vegas. Las Vegas has to have some connection to what's going on here.
How about Hawaii for about 8 months?
That's wonderful too. You know, send your attorney to Hawaii. I think that's a good cause that we can do a GoFundMe on. Is that a question I see?
It is. John is with you. John, go for it.
Hi, John. How are you doing?
I know this is not your specialty, but it involves a board meeting for a homeowners association, and we had a recall of the board members. And the board member, the president that is, read off the names of the people that signed the petition against them. Is that in any way a no-no as far as that you're aware of in the state of Florida?
Not that I'm aware of. I would think that if there's a petition for recall, it should be public knowledge to the homeowners association and the members who has signed the petition for recall. Otherwise, how do you judge whether or not it's a valid petition, whether you have a valid number of legitimate signatures? How can it be challenged?
I understand. Yeah, I understand that point. I'm not questioning whether it's public information. It's just that the need to read off every person who signed the petition is not needed at a recall. The votes are tabulated.
You're right. It's not needed, and it's probably intimidating, but I don't know of any statutory restriction on that.
Yeah, because she was calling these people before the meeting, and it kind of got like, why is she calling the people? I mean, everyone has a right to sign a petition, just like everyone has a right to vote. And for that, not in this case, but in voting, you know, we always honor the secret ballot. But in a way, well, I know what you're saying. I mean, there's nothing non-public about a petition. But to me,
and not all ballots are secret. When we vote in elections in this country, it's secret. But in a lot of contexts, votes are public. You know, if you go to local city council and they have a vote, it's not going to be secret. It's going to be public because of the Sunshine Act. Mm-hmm. So it really depends upon the situation. Yeah, it really depends upon the situation.
Okay. And if the same president at another meeting implied that someone was getting a gift for a developer who was coming into a community, that's kind of like a gray area as far as defaming the person she's implying receiving.
Well, if she's implying that they're getting a kickback or a bribe, I think that could be interpreted as an accusation of criminal conduct and defamatory.
So that would be a lot more serious than
yeah.
You know, even if she implied it, would be a lot more serious
yeah.
Instead of stating it directly.
Well, implications can be defamatory. The test is usually what would a reasonable listener interpret being said by the speaker.
Yeah.
And
if she had said, did you receive? Have you received any favors? I mean, is that more of a fair question instead of?
I think it's a fair question.
Devious.
Then they can answer no. But you know, there's a lot of defamation that goes on in homeowners association monthly newsletters, condo association newsletters. There's a lot of defamation in there. And there's a lot of defamation if these associations are big enough where they have their own internal board that people can post things on. There's a lot of defamation in there, I tell you. I've dealt with a few of them, and when they're clear in black and white, the person who made the defamatory conduct is never happy.
So it is winnable. It's not a high.
Oh no, it's winnable. It's winnable like any other defamation case. What matters is what was said. And so it becomes very specific as to what was said for an attorney to evaluate whether or not that's defamatory.
Now, the next question, was that board meeting taped?
It was supposed to be. It was a Zoom meeting. And people are telling me that it was recorded, but I haven't been able to find out how to go to Zoom to find out where to get that.
Well, you don't go to Zoom, you go to the board. If the board taped it,
them, and they said they didn't record. They said they didn't record it, but I had people on Zoom telling me that the record button was on. I'm not a Zoomster, so I don't know that. But if you look at the screen, apparently there's a little button that says.
There is, yes.
Ours automatically records.
Yeah.
Which is fine, except if you're having a regular meeting. In Florida is a two-party consent state. Both parties have to agree to audio recordings as opposed to video. And so if I'm having a meeting with a Zoom meeting with another attorney and I record it without their permission, I've committed a felony. And I hear the music. And so on that possible commission of a felony, we will have to pause for a week until next Friday, when I'll be back for Ask a Lawyer. My office number is 772-781-8003. And until next week, this is Stuart Address for Ask a Lawyer.
Have a good week. Get some sleep.
Yeah.
You've been listening to Ask a Lawyer right here on WPSL, Port St. Lucie, Talk of the Treasure Coast, webcaster to the world, and WSTU, Stuart, Martin County's Heritage Station.